And now, it's Boomer Life. Lifestyle discussion designed to make your life more engaging, meaningful, and complete. Celebrating the baby boomer generation, this is Boomer Life on CIL 650.
Do you swear to tell the truth and nothing but the truth, so cross your heart?
Hey, and welcome to the show.
Do you swear to tell the truth and nothing but the truth, so cross your heart?
Yeah, this is the Law Show on CL 650. I'm Zach Spencer, and today we're talking about a subject that is very stressful. If you've ever been through it, maybe somebody in your family has been in an accident, often a car accident, having to deal with ICBC, trying to work on some kind of settlement. Well, today we have two lawyers in studio from Macquarie LLP that specialize in personal injury car accidents. We have Kevin Hyde. Welcome back to the show, Kevin.
Thanks, Zach.
Kevin is a partner at Macquarie LLP, and Neil Mulholland is an associate counsel at Macquarie LLP, and your first time on the show, so welcome.
Thanks, Zach.
All right, you guys all ready to go?
Certainly.
All right, so we're getting into a subject that is sort of really painful for people while they're going through it, and I guess part of your job is a lot of hand-holding and getting people through the process and getting them a good result. So first of all, before we get into all of that, let's get into what you guys do at Macquarie LLP. So Neil, what's your specialty?
Well, my main focus and my main area of interest is in major loss and catastrophic loss claims. Mm-hmm. So that would include, for example, head injuries, serious psychiatric injuries such as post-traumatic stress. It includes things where the loss to the client, for example, in terms of their ability to earn income or enjoy life or simply look after their family or their household, is significant and tends to be very, very long-lasting. Mm-hmm. I also have a particular focus on trial work, and the 3% or so of ICBC claims that do proceed to trial, those are areas that I have a particular sort of fascination for, if you will, mm-hmm. and a lot of my work involves helping other lawyers in the firm as their cases approach trial or, in fact, go to trial.
So are complex files more likely to go to trial?
As a general rule, yes.
There's bigger numbers at stake, right?
Bigger numbers at stake, and there are more areas of potential disagreement. Mm-hmm. You know, generally speaking, the reason why 97% of these things settle out of court is because once we have all of the medical assessments and other information that we need, two reasonable lawyers can generally arrive at a number they can both live with. Mm-hmm. The cases that go to trial, and obviously, a lot of them involve a dispute over who caused the accident, and that's one thing. We call that liability. But when they involve disputes over the amount of damages, they often involve a serious difference of opinion, often between the doctors themselves over things like, for example, what caused the injury? Was the injury something that might have happened in any event as a result of some, say, underlying disease like arthritis, for example? They may argue over how severe the injury is, and does it really have the functional impacts, the impacts on people's ability to live their lives that the client says it does and the doctors say it does. And as you pointed out, when there's more at stake, people are more likely to take that risky path of going to trial. Mm-hmm. And conversely, the reason why a lot of things don't go to trial, again, is because it is risky.
Yeah, because you don't always get what you want, right? You can sometimes get less.
Well, in practice, people almost never get what they want.
Right. So isn't that the old saying is if both sides are unhappy, then it's probably a good settlement? Is that
very
true?
Much so.
Yeah.
Yep. And I mean, having worked at the beginning of my career, I worked in-house for ICBC for about 5 years. And during that time, I handled probably over 1,000 cases at one stage or another, did quite a few mediations, and almost every single example where we settled a claim at mediation, the adjuster and I would be riding the elevator down to the parkade together at the end of the day, and in almost every case, the adjuster would say, "We paid that guy too much." And since I switched to the plaintiff's side of things in 2003, I've had the same comment with my own clients going down the elevator to the parkade at the end of a mediation. We settled for too little.
Right.
I think the mediator's truly done their job if both sides, as you said, Zach, walk away feeling like they...
There's a critical point to that, too, and that means to reach a settlement, you've got to be able to give something up.
That's the art of negotiation.
Exactly.
So when you look at your career, have you become a much better negotiator over the years? Is that the skill that you really hone in on at the end of the trial or the end of the negotiations?
It is, because that's where 97% of your claims will end up, in negotiation in one forum or another. It could be as simple as an exchange of emails. It could be as complex as a 16-hour mediation.
Right.
But at the end of the day, your ability to obtain a bargain that your client finds acceptable is really the measure of your skill in this business.
All right, we want to bring in Kevin because you touched on the fact that you work for ICBC and you have represented ICBC, and then you can both jump in on this. So as a layperson, we think that ICBC there in North Vancouver, their head office, has a whole floor of lawyers that just deal with this stuff, but that's not always the case. They have, as you say, maybe in-house lawyers, but they also hire firms to do this as well. Is that true?
Yes, that's exactly correct.
Do they still have in-house lawyers, as you were mentioning?
They do have some in-house lawyers, and Neil was one of them for, I believe, 5 years. But they also hire out law firms to do their work for them.
So they sub that out.
They sub it out. And Macquarie Hunter, since the creation of ICBC.
Oh, you got to put a quarter in the quarter jar.
Yeah,
it's Macquarie LLP. So there, because we started doing the show as Macquarie, the former name. Yeah. So every time you say the former name, you have to put a quarter in the quarter jar. You're the first one to pay in, by the way.
I did it a few times last time too. You're good at policing this. As I was saying, though, Macquarie LLP has been doing ICBC work since pretty much ICBC came into existence for several years, and we just ended our contract recently.
So is that a sort of a fundamental choice with the partners to say, we really should take a stand one side or the other?
Our decision at the partnership level was to increase the resources we're putting towards our personal injury group, and that is one of our more profitable groups at our firm. We have some great lawyers that were already in that group, and we have some lawyers that used to work for ICBC that are now incorporated into that group as well. So
do you think you'll have firms that just represent ICBC and hopefully firms that just represent plaintiffs and don't mix it up? Because you can see as a layperson there's a bit of a conflict of interest there. Or you could look at it and say, well, they have more inside knowledge because they know how the system works.
It is definitely, you're correct in saying that it is somewhat a conflict. When I used to do both ICBC work and personal injury work, I'd sometimes be talking to an adjuster about an ICBC file, which I was working on for ICBC, and then have to take off my ICBC cap and say, well, while I have you on the phone, let's talk about this file where we're on the opposite ends. And yes, of course, I look back, and I think Neil will agree that a lot of the experience I gained from being an ICBC lawyer was very valuable. Just seeing how they operate with the managers, with the adjusters, and having those conversations has definitely helped me to become a better personal injury lawyer. But being a personal injury lawyer is definitely what was always my goal.
Now, with both of you having represented ICBC in the past, as back to the layperson again, we always think that they're kind of out to get you to pay the least amount possible, or are they quite fair and they want to come with a fair settlement? Or so you're both smiling. What do you think about that?
Well, it's interesting you use that word fair, because I often will tell a client that fair is a place on the corner of Hastings and Renfrew where you can ride the Midway and get some cotton candy.
Oh, well done. I like that.
It's one of those concepts that everybody has a different idea of.
Yes.
In fact, when you've been through
I have that with my kids. I say, this might not seem fair to you, but it's fair to me.
Absolutely.
Yeah.
And of course, when you've been through a 3-year ordeal where you've been in pain and lost maybe a year and a half worth of income and spent a fortune on medical treatments and such, your idea of fair is very, very different from that of an adjuster sitting in an office someplace who has a mandate to pay you as little as possible.
So that is their mandate.
That is their mandate, obviously. And but I think a couple of things bear mentioning here. I mean, ICBC is really no different from any other insurance company in that respect.
Even though it's a sort of a crown corporation, right?
Well, at the end of the day, they don't exist to give money away. And, if they did, then the cost of driving a car in this province would be astronomical. The fact is that fair is a concept that's too fluid to really give you any guidance as to how a claim can be settled or what the result might end up being. What you look at is what's achievable. And what's achievable is based on what evidence you have. If your evidence shows that your client has lost his ability to do the job that he trained for, has lost the ability to look after his home, has lost the ability to participate fully in his family's life, and that's going to carry on indefinitely, and he's only 35, well, there is guidance in terms of precedents, cases, in terms of...
And is personal injury precedent-based? Is it always
Certainly.
that way? Okay.
Absolutely. So you would look to, for example, cases of people in similar circumstances whose injuries have had similar impacts on their ability to live their life.
Now, does that cross provincial boundaries? Can you take a case from New Brunswick, for example?
Not often.
No?
Not often. For some specific and very exceptional points, you might be able to. But as a general rule, Personal injury cases, particularly those that speak to the amount of damages that a particular injury would attract, those cases are very specific to different provinces simply because there is a different assessment, perhaps a different philosophy of assessment in terms of how someone's life might be impacted by injury.
Now, we live in a very expensive city, one of the most expensive anywhere. Does that factor in? Do you say, okay, the settlement, we live in a very expensive city. Yes, this person isn't going to be able to make the kind of money they were before, but the cost of living here is much more than New Brunswick.
Whether consciously or not, I believe that does play a role. Because at the end of the day, the guiding principle to assess damages for pain and suffering is what will it take to allow this guy to enjoy something like the quality of life he had prior to the injury, in as much as money can do that. And if you think about the sorts of amenities, the sorts of entertainments, the sorts of different things you might do to kind of take the edge off a long-term or permanent injury, they're going to be more expensive in this city than they will be in many parts of the country. No doubt about it.
Because I always thought that they looked at your earnings. Say you're a bricklayer, and you would know, bricklayer as a union job, say, and you can extrapolate out what it would maybe a fairly simple calculation, which is quite different than someone who's a hand surgeon, right? So that's based on their income, so you can calculate that. But how do you calculate in the cost of living part of it?
Well, we're talking about in one sense two different categories of damages here.
Yeah.
Okay, so when we talk about the kinds of losses that somebody suffers as a result of an injury, they often suffer a loss in their ability to earn income.
Right. So that's the calculating based on income, right?
Exactly. And in essence, the damages for that category are intended to put the person back in the place they would have been if the injury hadn't happened. So specifically, it's what income would this client have earned if they hadn't been injured in the accident of such and such date. That could be a simple thing. For example, if somebody is a skilled tradesman and earns more or less a constant wage and is employed for more or less a constant 40 hours a week, well, then it's more or less arithmetic to figure out what money they would have earned. On the other hand, if somebody is a commissioned salesperson, if they are self-employed in their own one-person business, if they are a realtor or a fee-for-service professional, in other words, the more variables that affect
the more they work, the more money they make, right?
Or their income can be affected by market conditions. If you're a realtor in Vancouver in 2008, you probably didn't like your income at the end of the year all that much, whereas in recent years things are rather different. And so calculating what somebody may have lost can be a complicated thing, particularly if as is more often the case, if they're a higher income earner, they're more likely to be either self-employed, professional.
Yes, or have a doctor will have their own business, right?
Exactly.
Yeah. All right, we're going to take a quick break because I'm gone a little bit off topic. I'm kind of jumped ahead a little bit as well. So we have in studio with us today Neil Mulholland, Associate Counsel at Macquarie LLP, and Kevin Hyde, Partner. And when we come back, we're going to get into what does it mean, what does a catastrophic loss and injury mean? And that's Neil's sort of specialty. And we're going to go through a bunch of other examples, and we'll get into what exactly you do at Macquarie LLP on The Law Show next on CL 650.
Celebrating the baby boomer lifestyle. This is Boomer Life on CL 650.